Good afternoon. Welcome to the Heritage Foundation and our Lewis Lehrman Auditorium. We, of course, welcome all those who are joining us on our heritage.org website on all of these occasions. Reminding our internet viewers that they can submit questions or comments at any time, simply emailing us at speaker@heritage.org. Those in-house are asked to make that last courtesy check that cell phones has been turned off as we prepare to begin. Hosting our program, of course, is Sarah Torre, policy analyst in our Richard and Helen DeVos Center for Religion and Civil Society. She focuses on policy issues related to religious liberty and marriage and the family. She posts regularly about these issues on the Foundry, Heritage's policy blog, and often directs readers in that instance to our other think tank website, familyfacts.org. She has been cited in the New York Times, among other media outlets. Her commentary has appeared in major newspapers and digital journals, including National Review Online, and she appears regularly on radio and other programs across the country. She also speaks to student groups and audiences on Capitol Hill on her main issues. Please join me in welcoming Sarah Torre. Sarah?
Thank you, John, and thank you all for joining us today. It was 1 year ago this afternoon that justice was served for a few infants and one mother whose lives were taken within the filthy walls of 3801 Lancaster Avenue. Philadelphia late-term abortionist Kermit Gosnell was convicted of first-degree murder in the deaths of 3 infants born after botched abortions. In addition to more than 200 other criminal counts, Gosnell was convicted of involuntary manslaughter in the death of Karnamaya Mongar. The 41-year-old woman died from an overdose of anesthetic drugs during an abortion procedure in his rundown clinic. The details of Gosnell's 6-week murder trial are gruesome. According to the almost 300-page grand jury report, the murder of newborn infants after failed late-term abortions was a regular occurrence during the 40 years Gosnell ran his clinic. Gosnell's disregard for the dignity of human life extended to the vulnerable mothers of the infants he murdered. Prosecutors and clinic staff testified to the decaying operating rooms stocked with filthy, corroded instruments. Despite reports of death, injury, and dangerous conditions, Gosnell's House of Horrors went uninspected by the state for almost 2 decades. As we mark 1 year from the conviction of Kermit Gosnell, we must face the reality that he is not merely an outlier in the abortion industry. Dozens of other abortion clinics across the country have faced investigations, criminal charges, and complaints. Many continue their work with little to no oversight or inspection. Even in the sterile abortion facilities, legal abortion can expose women to physical and emotional harm. Failing to protect the safety of women and defend the lives of unborn children from late-term abortion has made the United States abortion laws extreme among developed nations. Gosnell's trial and conviction shed light on one of the darker corners of the U.S. abortion industry and reinvigorated debate about late-term abortion and the health and safety of women. We'd like to continue that discussion today with our expert panel, who will explore the medical evidence of abortion's harm to women, the state of late-term abortion laws in the United States, and how states are protecting women and children. Joining us today is Dr. Byron Calhoun. He serves as professor and vice chair in the Department of Obstetrics and Gynecology at the West Virginia University, Charleston. He has over 25 years of clinical experience in obstetrics and gynecology and maternal-fetal medicine. In addition to authoring over 70 peer-reviewed articles, he has participated in dozens of research projects and has published numerous articles on medical and ethical aspects of obstetrics and gynecology. He is a distinguished graduate of the United States Air Force Academy and graduated from the University of Iowa Medical School. We're delighted to have Dr. Calhoun here to share with us some of the medical evidence on abortion's negative impact on women. We also have Angelina Baglini, who is an associate scholar with the Charlotte Lozier Institute. She received her Bachelor of Arts in Philosophy from the University of Notre Dame and her JD from Arizona State University. She was named a Blackstone Fellow by Alliance Defending Freedom in 2011 and has worked with the Center for Arizona Policy, researching and supporting pro-life legislation in Arizona. Angelina will present her research on late-term abortion law in the United States as compared to other countries in the world. Welcome, Angelina. Teresa Collette is a law professor at the University of St. Thomas. She has published numerous legal articles and is the co-author of a law casebook on professional responsibility. Teresa is an elected member of the American Law Institute and has testified before committees of the United States Senate and House of Representatives. She has served as Special Attorney General for Oklahoma and Kansas, as well as assisting other state attorneys general in defending laws protecting human life. Teresa will share her thoughts on why states have a legitimate interest in protecting women from the harms of abortion given Supreme Court jurisprudence. Ovid LaMontagne is General Counsel of Americans United for Life, where he manages AUL's Legal and Government Affairs divisions. Ovid was formerly a shareholder at one of New Hampshire's top law firms, Devine Willamette and Branch, where he has served since 1986. In addition to his distinguished legal career, Ovid has also run for the U.S. Senate seat in 2010 and winning the Republican nomination for governor of New Hampshire in both 1996 and 2012. A graduate of the Catholic University of America, he earned his J.D. from the University of Wyoming College of Law. And Ovid will explain some of the ways that states are taking actions to protect both women and the children they carry. Following the panel discussion today, we are very honored to have Dr. Charmaine Yost, President of the Americans United for Life, will give a reflection on the anniversary of Gosnell's conviction and how we can move forward to the greater protection of women and children. So with that, I'll turn it over to Byron.
Well, I'm flattered and humbled to be asked to make a few comments today on the anniversary of the conviction of Dr. Kermit Gosnell for the crimes committed while the provision of the alleged safe and rare abortions in his clinic. At a moment like this, I'm reminded of the pointed words of that great Irish statesman of the 18th century, Edmund Burke, who observed that all is necessary for the triumph of evil is for good men and good women to do nothing. And it seems that what was done has been nothing, and what has been done for years by all the parties involved with the case of Dr. Gosnell. Unfortunately, the lack of oversight, regulation, and accountability afforded to abortion clinics, abortion providers, and the abortion industry remains an inexplicable medical anomaly. No other medical or service industry is allowed to act with such impunity or freedom from external peer review or administrative review. For instance, for example, in my own state of West Virginia, there's no oversight or inspection by the state in the operations of the abortion clinics or industry. Yet, West Virginia maintains a strict oversight and state inspection of cosmetologists, tattoo parlors, and veterinarian clinics. The remainder of the medical community performing outpatient surgeries must undergo strict scrutiny, maintain external impartial review, such as Joint Commission, and be inspected regularly by state agencies. The abortion industry and providers like to tout the uniqueness of their provision of their services and how they deserve special consideration in the performance of this care. I could not agree more. In fact, the Supreme Court in 1992 in Casey found that the care was particularly unique in abortion clinics because it was the only type of care that was rendered which routinely ended in the death of a member of the human race or the species Homo sapiens. This finding was so compelling according to the court's ruling that anything that might bear on a reasonable person's decision to perform an abortion ought to be shared with the patient as a part of informed consent. Yet the abortion industry, along with the American College of Obstetricians and Gynecologists, steadfastly refused to admit to any complications with abortion, in spite of the overwhelming published peer review research to the contrary. This peer review research and data includes over 140 papers demonstrating increased risk for preterm birth, with at least 2 large meta-analysis papers with an increased risk of preterm birth, that is, with particularly surgical abortions. In these 2 large published peer review analyses, surgical abortions demonstrated an average risk of birth less than 32 weeks from 35 to 64% for just a single abortion, and increasing to greater than a 70% risk for preterm birth with more than 1 surgical abortion. Now, we must note that preterm births below 32 weeks are those most likely to suffer severe morbidities, such as cerebral palsy, blindness, deafness, and learning disabilities. Also published in large peer reviews, a large quantitative analysis on mental health post-abortion, which has found an increased risk for mental health issues in women post-abortion. This paper particularly found a disturbing 81% increased risk of mental health problems in women post-abortion, 81%. The paper further found a disturbing finding in the quantitative analysis that virtually 10% of the mental health problems in women in general could be afforded specifically attributed to abortion, 10%. The published data on abortion mortality has at least 2 large record-linked peer-reviewed studies from Finland that have matched for both demographic and social data. These studies found not a decreased risk, but a 3 to 4 times increased risk for death after an abortion versus a woman carrying a child to term. Finally, and most importantly, suicide rates in the peer-reviewed record-linked journals studying women undergoing abortion found suicide rates were increased from 50 to 600% in women who had abortion compared to those giving birth. Remember, linked studies with all the data. This lack of informed consent to abortion would seem incredible enough to the average individual. There was not even a more egregious and equally disturbing abortion-related care issue. This disturbing issue is that a physician is allowed to perform gynecologic surgery on a patient in an outpatient setting with virtually no ability to care for them in an emergency. That is, to perform emergency surgery up to including hysterectomy, resuscitate the patients, provide anesthesia, or transfuse patients with blood. No other group of providers possesses the luxury of operating on or performing outpatient medical procedures on patients, only to send them to an emergency room as unassigned and abandon patients. All other providers must have strict protocols in place for clinical follow-up of their patients with surgical or medical complications. If not personally as the provider, then the providers must arrange for a group of like-skilled providers who agree together to provide 24/7 care on the patients for post-procedure complications. To do otherwise is considered abandonment of the patient and considered in any other area of medicine malpractice. So pervasive is this practice of abandonment by abortion providers that states have been forced to enact legislation requiring abortion providers to provide comprehensive clinical care. The legislation necessarily had to include specific and clear guidelines and regulations for abortion providers to claim clinical admitting privileges at hospitals and surgical privileges for the care of abortion complications to prevent patient abandonment. And the abortion industry howls with dismay at even this reasonable standard of care for women. We do agree that abortion is unique as a surgical or medical procedure. This uniqueness consists in the ending the life of the member of the species Homo sapiens. As such, we would contend that holding the abortion industry and abortion providers to at least a minimum accepted standard of surgical and postoperative care required for all those surgical procedures seems reasonable. Therefore, we categorically assert that all women really do deserve excellent clinical, surgical, and postoperative care under the same accepted guidelines and safety procedures that all other surgical centers are required to maintain. Women and our legislators need to ensure that the providers of abortion care are required to have the same skills, the same operative equipment, the same resuscitative equipment, the same credentials, the same training, the same oversight as every other surgical center must undergo. Women simply deserve better.
Thank you very much, Dr. Calhoun. Angelina?
Well, thank you to the Heritage Foundation and to Sarah for inviting me to speak with you all today. I'd like to share with you some of the research that we recently released concerning gestational limits on abortion in comparing the United States to international norms. I'd like to share with you how we began this research endeavor and what the purpose of the study was and what we set out to accomplish. I'll highlight for you some research findings, some notable statistics along the way. So how the research began was centered around the recent debate over legislation being introduced in various states to uphold women's health and protect the unborn by regulating abortion practices. The topic of intense focus has been 20-week abortion laws that limit abortion to the gestational age that an unborn child is capable of feeling pain. Promoters of the 20-week abortion laws have cited that 20-week abortion laws are neither extreme nor uncommon. The common statistic that was thrown out is that the U.S. was one of 4 countries worldwide that permits elective abortion through the 5th month of pregnancy, alongside China, North Korea, and Canada. The purpose of this study was to verify whether that statistic was in fact true and where the United States falls in terms of its permissiveness of elective abortion policy. The sample group that we included for this project was 198 countries, independent states, and semi-autonomous regions with populations exceeding 1 million. So 198 countries was our sample study. Of these 198 countries, independent states, and regions, 59 allow abortion on demand or elective abortion. The remaining 139 countries require at least some baseline reason to obtain an abortion. This can range from the most restrictive reason to save the life of the mother or completely prohibited, to the least restrictive, which is commonly known as socioeconomic grounds, with various reasons in between from the mother's mental and physical health. This report finds that the United States is one of only 7 countries in the world that permit abortion, elective abortion, past 20 weeks. In order to create a baseline for terminology in measuring the different statutes of countries, This report used gestation to compare restrictions on elective abortion that are based on duration of pregnancy. Gestational age marks the duration of pregnancy, which is most commonly and medically measured from the date of the woman's last menstrual period. This is the most identifiable date, medically speaking, which occurs approximately 2 weeks before conception or fertilization. More than 80% of countries already use gestation in establishing duration of pregnancy restrictions in terms of elective abortion, and it's the way which is most commonly used to measure the age of the unborn child alongside a common medical practice. In terms of the scope of elective abortion permissiveness, of the 59 countries permitting elective abortion, 9 countries limit elective abortion before the 12th week of gestation. 36 countries limit elective abortion at 12 weeks gestation. 6 countries limit elective abortion between 12 and 20 weeks gestation. And 7 countries permit elective abortion past 20 weeks or have no gestational limit at all. One country maintains a federal system, this is Australia, where abortion policy is determined on a state or territory level, and at least 2 of the states within that country permit elective abortion past 20 weeks. Compiling these countries overall, more than 75% of countries permitting elective abortion do not permit elective abortion past 12 weeks gestation. Only 12%, 7 out of 59 countries, allow elective abortion past 20 weeks. The U.S. is among those 7 countries that allow abortion past 20 weeks. And no matter how duration of pregnancy is measured, all countries in this category pass the threshold of allowing elective abortion past 20 weeks. The countries in this category are Canada, which has no restriction in law, China, which also has no restriction in law, the Netherlands, which has a restriction at 24 weeks, North Korea, which has no restriction in law, Singapore, which has a restriction at 24 weeks, the United States, which has no national gestational limit, and Vietnam, which has a limit at 24 weeks gestation. The United States is within the top 4% of most permissive abortion policies in the world, 7 out of 198 countries, when analyzing the restrictions on elective abortion based on duration of pregnancy. In terms of gestational limits, the United States ranks among 7 countries with the most permissive abortion policies. The clear norm among countries that allow elective abortion is to limit abortion before 20 weeks, and in most cases to limit abortion to 12 weeks, which is commonly known as the first trimester of pregnancy. 20-week abortion laws in the United States are neither extreme nor unreasonable. Rather, they move the United States towards international norms of legislating what is safe and healthy for the mother and what grants the unborn child more protection in the womb at the age where they are capable of feeling pain. Thank you.
Thank you very much, Angelina. That was eye-opening to see how permissive our own abortion laws are. Teresa, would you like to go?
Thank you for having me. I'm delighted to be here. And I think this is a really important anniversary for us to commemorate. I think my task on the panel is to situate domestic law within the context of legislative efforts as well as judicial oversight and restraint. Prior to 1973, the vast majority of states in this country did not permit abortion except under very limited circumstances. So the idea of regulating abortion as a routine medical practice simply was not within a legislator's lexicon. But in 1973, in a case that was initially accepted by the U.S. Supreme Court on a very limited procedural jurisdictional issue that Clark Forsyth of Americans United for Life has written extensively about in his book regarding the history of Roe versus Wade, in a case that was intended to simply answer what to anyone other than lawyers would be an exceedingly dull civil procedure question. The court decided to go beyond that and to make a determination about the constitutionality of whether or not the practice of abortion was protected within the privacy that was initially articulated by the court in a series of cases concerning contraception. In Roe v. Wade, as we all know, the court in fact decided that the Constitution did protect the practice of physicians and patients related to abortion. And in that case, the court set up what was to become the trimester system. In the first trimester, absolutely no regulation was allowed. And in the second trimester, the state must justify it merely in terms of protecting the woman's health. It was only post-viability that the state could take into account the fact that the object of the abortion was to end the life of an unborn child. We went through a long series of cases then as states struggled to regulate the practice in such a way to minimize abortions within their states and to encourage healthy births to women. But the court got increasingly radical and at one point even went so far as to strike down a law that merely required a second physician be present in the room for an abortion in the late term in order to sustain the life of the child if the child were born alive from the abortion. After the court reached that apex, there was a shift as Americans continued to protest this unlimited license for abortion. And we began to see the court back off initially in the Webster case. In the Webster case, the court recognized that the state had legitimate interests in fact, regulating abortion for purposes even in the first trimester. And in Casey, the court, in a plurality opinion, an opinion that under normal circumstances would not be binding on subsequent opinions, the court upheld Pennsylvania regulations requiring simple things like statistical reporting related to abortion so the public health aspects could be determined by epidemiologists and other researchers. Up until that time, the United States Supreme Court had taken a dim view of even reporting the number of abortions, the stage of gestation, the type of procedure, the sort of normal health information that would be necessary in order to determine its public health impact. They also approved a parent's right to consent to an abortion related to their minor children. Again, what would be a standard procedure in almost any other non-emergency procedure. Anything from setting a broken limb to other sort of more elective surgeries related to minors. And the court put to rest the debate raging among the Court of Appeals about whether parents could consent or withhold consent. But in even that case, they carved out a unique rule that said that the girl must have access to a separate judicial proceeding where her anonymity would be protected and where she could argue against having her parents involved in the decision. Her parents were not allowed to even know of this court proceeding. It's the only proceeding I'm aware of outside of national security hearings where someone can lose constitutional rights with no notice or opportunity to be heard. How many times will a teenage girl say, my own daughters probably have said, if I got pregnant, my parents would kill me. Well, that's not true. Their parents would be grievously disappointed, but would love her and protect her. And so even those normal regulations that we saw in all other contexts were in question until Planned Parenthood versus Casey in 1992. The court also upheld the ability of states and recognized that they had long undervalued state interests. They did away with the trimester system, which allowed greater ability of the states to regulate things like the necessity of certain equipment being placed in abortion clinics, the ability to require certain licensing, and the admissibility requirement that a doctor have admitting privileges at a hospital within a certain range from their clinic should something go terribly wrong during the process of abortion. So once this was upheld by the United States Supreme Court, one would think that Pennsylvania had some of the most effectively operated and regulated clinics in the country. But what happened? Politics intervened. And a governor decided that because these regulations, the sort of normal health and safety regulations that we would see in any other context, because these regulations, in the words of the government, might create some sort of barrier to women accessing abortion, he instructed the Department of Health not to investigate whether or not clinics were abiding by those standards. That instruction bound the Department of Health, even in the face of urgent cries from other physicians in the community, to look into Kermit Gosnell's clinic. And Gosnell's clinic was only investigated not because of the death of patients, not because ambulance drivers had reported they couldn't even get a gurney through the halls that were too narrow to allow a woman who'd been injured during the abortion to be taken to the hospital for emergency care. It was only after an investigation about the fact that he was also dealing illegal drugs was started by national authorities that they began to investigate. Now that's led to an impetus for states across the union to look and see if the regulations they have in place are adequate and if they're being enforced. And sadly, the simple fact is that very few states have regulated to the full extent permitted under the Constitution and under current United States Supreme Court. In my own home state of Minnesota, we do not have a viability ban. In other words, abortions in my home state can occur all the way through the 36th week. A woman could be in labor, and if she says, I want the baby aborted instead of delivered, an abortion provider could comply with that request with absolutely no legal sanction. We have no clinic regs in our state. And so, as Dr. Calhoun noted, we regulate even hair braiding in our state. We will not regulate doctors who are doing abortions or using using pharmaceutical products that were approved only under a unique emergency provision under the FDA, because RU486, the abortion pill, did not go through the normal vetting and full testing and clinical trials requirements that we see of other drugs. And yet, because of that, our women are unprotected. In other states like Pennsylvania, regulations are in place, but they're simply not enforced by local health authorities who, under some misguided conception of the women's good, believe that it's more important that women have access to abortions no matter how unsafe than it is to make sure that the clinics are abiding by regulations. And then finally, we have a very small category of states like the state of Texas, in which we have a governor and a Department of Health who are serious about protecting women's health. And let me close with just a short commentary upon a recent case that came out of the Fifth Circuit. In that case, Planned Parenthood had sued the state of Texas, asking that the constitutionality of an admitting privileges requirement as well as regulation of RU486 be struck down. The federal district court in that case, Judge Sparks, a judge to whom they have made often recourse seeking to have laws struck down unconstitutionally, agreed with Planned Parenthood, as is his practice historically, and the case was taken up to the United States taken up to the Fifth Circuit, where an all-woman panel said that the state of Texas, of course, had an adequate state interest to require admitting privileges for any abortion provider within 30 minutes of the clinic. A requirement, I would note, that the abortion industry itself had advocated for just 10 years earlier on the websites of the National Federation of Abortion. They also upheld the regulation of RU486 and requirement that doctors use that drug consistent with the protocols that were used in the clinical trials prior to its approval by the FDA. Feminists were outraged. But that shows you the continuing battle we have over abortion regulation. And it is my hope that this panel, sponsored by Heritage, will increase the willingness of states to leave that first category, the category that my state of Minnesota is in, that leaves women completely unprotected, and the second category where the protection is on the books but unenforced, and join the category that the state of Texas occupies, where women are protected by reasonable health and safe regulations throughout their pregnancy. Thank you.
Thank you very much, Teresa. That was an excellent overview of how states can, even in the jurisprudence of Roe v. Wade and Casey, take actions to protect women. And Ovid's going to give us some additional examples of how they can actually do that.
Well, thank you, Sarah, and thank you, the Heritage Foundation, for sponsoring and hosting this panel. I'm honored to be accompanied by some leading and distinguished members of our professions, the medical profession and the legal profession. And just to summarize what you've heard so far, Byron Calhoun told you, in no uncertain terms, that abortion harms women. Abortion harms women, particularly in late-term abortions, and the medical evidence is clear, peer-reviewed, tested, and admissible in a court of law to support either legislation or litigation. The body of knowledge is there. Science is catching up to this industry that's unregulated and unrepentant. Angelina told you how extreme America's abortion position is. And it's true. 7 countries, including the United States, allow abortion past 20 weeks. But we are one of 4 countries that allow abortion through the 9th month. If you talk to fellow citizens, they don't believe that, but that is the case. Roe versus Wade and Doe versus Bolton set forth the extreme position we currently have in the United States. And Teresa Collette, a distinguished law professor, told you in no uncertain terms that the states have the authority under this Constitution as interpreted, whether we agree with the interpretation and construction or not of the Supreme Court. As current law exists, states have the ability, and I would say the duty, to regulate abortion. So let's talk about this event today. We're not here to commemorate or recognize an historic moment in time when Kermit Gosnell was convicted of murder and of manslaughter. We're here today to reflect on that and to draw lessons from it. That case has to have vitality, otherwise the death of those babies through the scissors on the back of their spines, killing them, the death of Karnamaya Mongar, the immigrant, refugee to this country who died in his clinic. Those deaths will be in vain if we don't learn our lessons from that case. And the most significant lesson to be learned is there was in this country a catastrophic system failure at all governmental levels. Catastrophic. And what do I mean by that? If you haven't read the grand jury report, all 261 pages of it, you ought to. It is sobering, and I thank to the bottom of my heart the men and women who served on that grand jury and did this investigation. They asked the question, why did this go on so long? And this is what they said at page 137. The callous killing of babies outside the womb, the routinely performed 3rd trimester abortions, the deaths of at least 2 patients, and the grievous health risks inflicted on countless other women by Gosnell and his unlicensed staff are not the only shocking things that this grand jury investigation uncovered. Are you kidding? That is shocking, but that's not the most shocking thing. What surprised the jurors even more is the official neglect that allowed these crimes and conditions to persist for years in a Philadelphia medical facility. And they go on. These men and women, citizens in this grand jury. We discovered that Pennsylvania's Department of Health has deliberately chosen not to enforce laws that should afford patients at abortion clinics the same safeguards and assurances of quality health care as patients of other medical service providers. Even nail salons in Pennsylvania are monitored more closely for client safety. Indeed, the department has shown an utter disregard for both the safety of women who seek treatment at abortion clinics and for the health of fetuses after they have become viable. State officials have also shown a disregard for the laws the department is supposed to enforce. Most appalling of all, the Department of Health's neglect of the abortion patient's safety and of Pennsylvania laws is clearly not inadvertent, it is by design. Sadly, that design is not a partisan issue. It's bipartisan. In the grand jury report and during the grand jury investigation, a witness testified on behalf of the state and who was working with the Department of Health. She blamed the decision to abandon annual inspections of abortion clinics in Pennsylvania on Department of Health lawyers who, she said, changed their legal opinions and advice to suit the policy preferences of different governors. Under Governor Robert Casey, she said, the department inspected abortion facilities annually. Yet when Governor Tom Ridge, a Republican, came in, and those are my words, a Republican, The attorneys interpreted the same regulations that had permitted annual inspections for years to no longer authorize those inspections. Then only complaint-driven inspections supposedly were authorized. Stolowski said that the Department of Health's policy during Governor Ridge's administration was motivated by a desire not to be putting up a barrier to women seeking abortions. The state legislature, they went on to say, gave DOH, the Department of Health, the duty to enforce its regulations, the authority and power to do so are implicit in that duty. The department abandoned this responsibility without explanation and without notice of the public or the legislature. Ladies and gentlemen, we are a nation based on the rule of law. We are not a nation in which there is a king or queen or some sovereign. We are the sovereign, and government officials work for us. And the most basic civics class in this country hopefully still teaches that there are three branches of government. One branch makes the laws, and that's the legislature. Another branch enforces the laws made by the elected officials who represent us in the legislature. And the courts of this country are charged with adjudicating cases and controversies regarding those laws. It is not the role of any executive anywhere in this country or his administration to refuse to enforce the laws passed by the legislature, no more than it is suitable for an attorney general, elected or appointed, to choose not to enforce or defend the laws of the state, or the attorney general of this country to refuse to enforce and defend the laws enacted by the Congress. And what are we seeing in today's America? Unilateral decisions by executive officials to either ignore or refuse to enforce the laws of this country. That is one of the lessons of the Gosnell case, a systemic failure of government. And listen to this, what they found too. The lawyers, and my profession, the lawyers were complicit in this and in fact enablers. The rationale for not enforcing the Pennsylvania law included that abortion is a controversial issue. What the grand jury found at page 163, a second reason proffered by DOH attorneys for not licensing abortion clinic, that abortion is controversial, quote unquote, is just insulting. Thank you, gentlemen and ladies of Pennsylvania grand jury. They went on to say abortion is a legal medical procedure. Any controversy surrounding the issue should not affect how the law is enforced or whether the Department of Health protects the safety of women seeking health care. The Act gives the Department of Health all the power it needs to assure safe abortion clinics, yet instead of applying the law as it is written and counseling DOH to license abortion clinics as ambulatory surgical facilities, these lawyers have used illogical arguments to evade the Health Care Facilities Act. And this is the last paragraph of the grand jury's report on page 261. The Department of State literally licensed Gosnell's criminally dangerous behavior. DOH gave its stamp of approval to his facility. These agencies do not deserve the public's trust. The fate of Karnamaya Mongar and countless babies with severed spinal cords is proof that people at those departments were not doing their jobs. Those charged with protecting the public must do better. So how did this come about that we had this kind of systemic catastrophic failure in Pennsylvania? And I submit to you that we're having the systemic catastrophic failure throughout the country. Well, let's begin with the United States Supreme Court. As my colleague Clark Forsythe, and I thank you for quoting Clark and his good work, Abuse of Discretion, still available on Amazon, and a fine read even for lay people. As Clark says, the United States Supreme Court, with Roe v. Wade and Doe v. Bolton and subsequent jurisprudence, has created a public health vacuum when it comes to abortion. Sandra Day O'Connor said in Akron, she really chastised the court for having established itself as the nation's ex officio medical board with powers to approve or disapprove medical and operative practices and standards throughout the United States when it comes to abortion. Where in the Constitution does the court hold for itself the power to regulate or legislate? But it has created this vacuum, public health vacuum in abortion. And our friends on the other side, the pro-abortion forces of this country, have exploited this vacuum to the extreme. And Angelina's report shows how extreme it is. And they want to create this situation that states don't have the ability to regulate abortion. They want to perpetuate the controversy and exploit it to victimize women and unborn children in this country. The Supreme Court has said, so there's no doubters out there, that abortion, even though it is a special procedure, as Dr. Calhoun noted, it is a unique procedure which involves the taking of human life, and the court is not ignorant of that. But the court has noted that when it comes to abortion regulation, there should be no special status granted. As Justice Kennedy wrote in Gonzalez versus Carhart, the court has given the state and federal legislatures wide discretion to pass legislation in areas where there is medical and scientific uncertainty. This traditional rule is consistent with Casey. The law need not give abortion doctors unfettered choice in the course of their medical practice, nor should it elevate their status above other physicians in the medical community. So to those in the public square who say we can't regulate abortion, they're wrong. To those in the public square who say we should not regulate abortion, they're dead wrong, because the science compels it. We have room to legislate. So at Americans United for Life, what we developed last summer in the wake of the Gosnell conviction and the horrific information that was confirmed by his guilty verdicts, as reported in the grand jury, we decided to develop the Women's Protection Project, a compilation of bills that we've drafted over the years, model bills including clinic regulations, and you could have picked up a copy of our Women's Protection Project on the way in, and you can certainly find it at AUL.org. That's AUL.org. We have it posted there along with our other model legislation. But coming from the private sector, one item that's new to that Women's Protection Project, which I challenge my colleagues to develop, from my own experience in the private sector representing private businesses, we developed what we call an enforcement module. That enforcement module is a standalone law that empowers the government, in the first instance, to enforce criminal laws and bring civil sanctions against abortion providers who violate law. But more importantly, it creates a private right of action in citizens and organizations after due notice to government authorities when they know there's a violation or suspect there's one in good faith, that they can bring the lawsuit themselves to enforce clinic laws, admitting privileges. Now you may think that sounds a little odd, a little extreme. Extremism begets extremism, but this is not extreme. If you look at environmental laws, for example, Clean Water Act, there is a private right of action that's recognized by individuals or organizations like the Conservation Law Foundation, which routinely sends letters of demand to businesses in this country. It says, Mr. Business, ABC, you are polluting a local tributary because you're allowing runoff into that tributary. And if you don't remediate in 30 days, please see the attached complaint, which we will file in the federal court to enforce the environmental laws. The time has come for citizens in this country to demand of their legislature the authority to enforce the laws of this country if the executive branch will not. After due notice to the executive branch, which includes the Attorney General, public health officials. And we think this is the next important step to take, in addition to developing and enacting the law. So Minnesota and New Hampshire are outliers in this country where abortion can happen through 9 months with no restrictions, that we in fact have a mechanism to enforce the laws if for whatever reason those in the executive branch choose not to. And we should be given that power. It's high time, in light of the Gosnell case, that Americans take action. Edmund Burke said it quite well. Evil is only allowed to perpetuate if good men and good women, I should say better women, do nothing. We can do something. The law permits it, the science compels it, and we will help you do it at Americans United for Life. Thank you.
Thank you very much, Oven, to all our panelists. You've heard now how abortion can harm women, the extreme medical evidence that is mounted of abortion's physical and emotional harm to women, how the United States is an outlier, really, and among other countries in terms of our permissive abortion laws, and how states and even private citizens through the enforcement module can act to protect women and save the lives of unborn children. Now I'm delighted to introduce Dr. Charmaine Yost. She is the president and CEO of Americans United for Life. AUL's legal strategists have been involved in every life-related case before the United States Supreme Court, beginning with Roe v. Wade. AUL is the pioneer of the state-based model legislative strategy, which has increased exponentially with significant victories in the past few years. Under Dr. Yost's leadership, AUL has pursued and refined a mother-child strategy that looks at the interests and vulnerabilities of both, protecting them from the abortion industry abuses. Dr. Yost has held positions in the Reagan administration and is Vice President of Communications at the Family Research Council. Dr. Yost served as the project director of the Family, Gender, and Tenure Project at the University of Virginia. A regular political commentator, Dr. Yost is also the co-author of Mother in the Middle, an examination of child care policy. She has a PhD in politics from the University of Virginia, and amidst all of her various duties, she and her husband Jack live with their 5 children in the Washington, D.C. area. Join me in welcoming Dr. Yost.
Thank you so much, Sarah, and I just really want to start by thanking the Heritage Foundation and for you in particular putting together this panel and lending the weight of the Heritage Foundation to this terrible commemoration that we've all come to today. And I really actually want to take a minute to thank all of you who've taken time out of the middle of your day for something that is as sobering as this event is. Because let's face it, we are as I'll talk about in a little bit, facing a real conspiracy of silence around this issue. And by taking the time to be here today, you are striking a blow on behalf of women and the babies who are suffering at the hand of the abortion industry. So in that vein, if you would indulge me for a minute, let's take a minute and have, let's have a mental image of an industry, let's say for the sake of argument, maybe mammography, where you had a clinic that was dirty and filthy and awful, and women were going in to get mammograms, and mysteriously for some reason, at a clip of about 1 a month, they were either dying or being severely injured by the equipment. Imagine what would happen in that scenario from the gatekeepers of women's health. What would happen if a woman died in any other circumstance other than an abortion clinic? You would have today, on the 1-year anniversary of a death like that, you would have parades, you would have demonstrations, you would have placards with that woman's face on it going up and down out here, right outside our doors in the nation's capital, calling people's attention to this incredible abuse of women. And yet, something very similar to that happened in Kermit Gosnell's clinic, and as Ovid very correctly said, happens every day in our country across from shore to shore. So when the media finally did give Kermit Gosnell's trial the minimal amount of attention that they did, there did seem to be a kind of awakening of conscience for many Americans who managed to hear about it. Those who were personally imposed, or even those who were somewhat indifferent, those who'd never even thought about it before, were confronted with a very harsh reality that there is little to no distinction in the abortion industry between abortion and infanticide. Our friend Lila Rose's videos from inside abortion clinics have backed this up, that there is very little distinction amongst those who practice this gruesome procedure. The trial was so moving and so troubling that even Planned Parenthood, the nation's largest abortion chain, felt compelled to issue a statement about the Gosnell conviction. Planned Parenthood said, "The jury has punished Kermit Gosnell for his appalling crimes. This verdict will ensure that no woman is victimized by Kermit Gosnell ever again." The question is, though, what about the other Kermit Gosnells that are still out there operating freely? And it's a little hard to imagine Planned Parenthood, which literally profits from killing babies and fights against any limits on abortion, It's a little hard to imagine that they were truly appalled that Gosnell had inverted the order of their usual method of kill baby first and then remove from womb. Of course, their vague reference to appalling crimes did not actually mention the babies, nor did it mention Karnamaya Mongar, the woman who was killed in Kermit Gosnell's clinic. There's an irony still in Planned Parenthood's focus on the women who were a victim to Gosnell's crime. Women are victimized every day in abortion clinics, including those operated by Planned Parenthood. In fact, if you hear nothing else that I say today, please remember that the latest data from the Centers for Disease Control shows that 1 woman every month dies from legal abortion. 1 every month. Take, for example, the tragic story of Tanya Reeves, a 24-year-old single mother in Chicago. She walked into the flagship Planned Parenthood on Michigan Avenue in Chicago across from the Art Institute and was not able to walk back out. In fact, going to Byron's point about abandonment, when she was finally taken to the emergency room, took them a while to figure out exactly what was going on with her, and other reports suggest that the Planned Parenthood clinic delayed 5 hours before taking her to the emergency room, and that this directly contributed to Tanya's death. But it's not just Tanya. She's not an outlier. Just this last month, on March 8th, Lakeisha Wilson, 22 years old, was pronounced dead after she stopped breathing at preterm, a downtown Cleveland abortion clinic. While death from abortion is certainly noteworthy, abortion, whether it's accomplished by an invasive surgical procedure or by taking a combination of potent drugs like RU46, carries many other physical harms to women. And we've already heard about that data today from both Byron and Teresa. But what really, really troubles me, and part of what gets me up in the morning to fight this battle, is that women across America are not hearing this truth. There is a conspiracy of silence with a tragic and inexplicable alliance between the abortion industry and the medical establishment in this country. Thank you, Byron Calhoun, for being here. For those of you who don't know Byron, he takes so much professional criticism for being a part of the pro-life movement. He's endangering his professional livelihood by being here today, and yet he inspires me by the number of times he's willing to stand up and tell the truth to American women. The medical establishment as a whole, however, will not speak up. They will not investigate. They consistently look the other way. Meanwhile, women are dying in these clinics, and those who survive suffer. It is an amazing and bizarre contradiction to me that while the abortion industry is struggling because they're having difficulty finding doctors who are willing to perform this gruesome procedure, particularly after they have firsthand experience with it and they discover that it's not what it was billed as, meanwhile, the medical establishment is doubling down on their philosophical commitment to recognizing and redefining abortion as fundamental health care and ensuring that it is embedded and entrenched within Obamacare. The babies and women killed and injured by abortion are more than mere data points. They are more than simple statistics. These mothers and children are all human beings with human dignity, and they are being robbed by an abortion industry. As I work to conclude, let's return to Planned Parenthood's statement on the Gosnell conviction last year and the doubts about their sincerity in truly caring for the women and babies who were victimized by Gosnell. Their conclusion was that this case has made clear that we must have and enforce laws. So one could be forgiven for thinking that finally we were coming to some sort of agreement. But no, let's remember, as we are thinking about where we move forward, we need to see the shift of where they went next. The case has made clear that we must have and enforce laws that protect access to safe and legal abortion, and we must reject misguided laws, they mean Americans United for Life, that would limit women's options and force them to seek treatment from criminals like Kermit Gosnell. So in other words, it's our fault. This is the Alice in Wonderland, up is down abortion industry at its best, and it is the response that we know very well. What the Gosnell case made public is something that we've seen over the years. The abortion industry is the red light district of medicine. Gosnell is sadly not an aberration. Ladies and gentlemen, we already have the back alley of abortion in this country, and the back alley of abortion in this country is legal abortion. The Gosnell case has made clear that mothers and babies deserve far better than the abortion-on-demand regime and the public health vacuum that Roe v. Wade has left in its wake. It is so very, very sad to me, but also fitting, that Kermit Gosnell was brought to justice in May, the month that we celebrate mothers. That gives us a little bit of hope that we are moving in the right direction. His trial and conviction rejects the false paradigm that the abortion debate is a battle between mothers and their children. We must take back the mother's side of this equation. They have been very successful over 40 years of positioning themselves as being on the side of mothers and us on the side of babies. As we are moving deeper into our 5th decade of fighting this, we must ensure that we are on the side of both mothers and babies together, because they are both being victimized by this industry. Let me finish where I started with Karnamaya Mongar, who lost her life in Kermit Gosnell's clinic and whose name today is lost to most Americans' memory. The grand jury report that Oved read from briefly, no less than 4 times mentioned the fact that the width of the hallways in his clinic were too narrow for them to even get a stretcher out once she went into arrest. Hallway widths contributed to her death because there is at least some speculation that she could have been saved at some point along the way in her tragedy. And yet, during his trial, I was invited to debate Elise Hogue, the president of NARAL, on PBS to talk about this case, and she went into an accusation against Americans United for Life and the pro-life movement, saying that we are somehow fixated on passing laws that have nothing to do with the safety of American women. And so I challenged her and I said, could you give us an example of one of those laws that you think is useless and not relevant to the safety of American women? In her response, after a moment, she took a breath and she said, well, for example, hallway widths. What does that have to do with anything? Well, I'll leave you with what it has to do with is the death of Karnamaya Mongar. Thank you again to the Heritage Foundation and to Sarah for putting this panel together and for remembering and for giving us a venue. Thank you all for being here, for remembering, and for committing ourselves to staying the course. And we're up against the establishment of both the medical establishment, the political establishment, the academic establishment, and their conspiracy of silence. And events like this today are a step in the direction of breaking that silence. Thank you.
Thank you very much, Charmaine. That were excellent reflections on Gosnell's conviction and where we can go from here. We have time for just a few questions. We have mics on either side of the auditorium. If you could please wait for the mic for the benefit of the people listening online. Please state your name and who on the panel you're directing your question to. In the back.
Hi, my name is Sophie Novak. I'm a reporter for National Journal. I think this question is probably best for Teresa, but I'm wondering, I know the case is still potentially in front of the Fifth Circuit in Texas, and that there's been some question of whether those challenges could potentially get elevated to the Supreme Court, depending on rulings in other states. And I'm wondering what your take on that would be, whether you see that as a possibility, and what some of the potential outcomes could be of legislation like that getting elevated to the Supreme Court.
Thank you. Certainly, a number of states have expressed interest in regulating the use of RU-46 in particular because of at least the evidence that caused the FDA to have a special meeting of experts related to whether or not it causes essentially toxic shock syndrome and the amount of hemorrhaging that can occur. So if, in fact, there is a cert petition, I think the Supreme Court would be interested, but we don't have a split in the circuits yet, and that's typically something that the Supreme Court is looking for before they take a case like that. There are other cases, of course. Arizona with the Ninth Circuit has a number of regulations that have been litigated. The Ninth Circuit struck down a 20-week ban. Cert was denied this session by the United States Supreme Court on that. Again, I think waiting for a circuit split. They currently have a sex and race-based abortion ban that will be presented to the Ninth Circuit. The Attorney General of Arizona just filed their response brief today on that issue. So I think we will see another abortion case before the United States Supreme Court next session, but I'm skeptical that it will be the RU-46 regulation.
Other questions?
Hi there, Nikki Schwab with U.S. News and World Report. I'm just curious if you think this Gosnell case will ever change the politics surrounding the abortion issue.
I'm happy to start as a recovering politician myself. I think it already has. People are becoming much more aware of the harm to women caused by abortion in light of that case, and also much more aware of the unregulated nature of this abortion industry. Americans largely believe that it is regulated, that it is limited, or as former President Clinton said, it is legal, safe, and rare. Well, it's neither safe and it's not rare. And this case really is a conversation starter on the campaign trail. It gives support for a 20-week ban, which is currently being presented to the U.S. Senate. At least the call for it to be voted on, I understand, is going to be answered. And so the momentum, I believe, having just joined Americans United for Life last year, I'm a newcomer to the pro-life movement professionally. I very much believe that the momentum is in our favor, largely because of what people learned about the abortion industry in the wake of the Gosnell conviction, which caused people to look at the underlying facts. But there's still a lot to do.
And if I could add something that hasn't been mentioned in today's conference, is that one of the responses we get to legislation regarding the need for clinic regulations is that the abortion industry itself is sufficiently self-regulating. And that's the sort of appeal to sort of a special interest of professionals, my own profession, the lawyers, right? We say, oh, the bar will regulate us, don't worry about these other things, thank you very much. But one of the interesting things in the grand jury report is that Gosnell actually did make application to the National Abortion Federation, which is, if you will, the voluntary sort of regulatory group. And their own report showed the appalling conditions in his clinic, and yet they did nothing to have legal enforcement of the regulations that were in place in that state. So I think not only is the lesson that these places exist, but also one of the lessons we can take from it is that the regulation through specialized professional groups simply is inadequate.
I'd like to add as well, along with the clinic regulations that were brought to light in the Gosnell case, that the American people have been polled, and a majority of the American people believe that late-term abortion is unacceptable. Even allowing a woman access to abortion that past 5 months, it's just, there's no acceptable reason medically to allow that practice to continue to happen in this country, and I think that especially brought that to light, that even Western Europe restricts abortion to 12 weeks. Why is America so behind even, what is seen as more progressive countries? So I think the humanity of the child, especially later in pregnancy, was definitely brought to light because of that case.
Absolutely. We have a question down here.
We're from Germantown, Maryland, where Leroy Carhart does second and third trimester abortions. One of the women who died, Jennifer Morabelli, we try to keep her name alive as well. And another woman was just maimed this spring, and she's trying to bring that to light legally. He flies in from Nebraska, and he comes usually on Sunday afternoon. He had 6 mothers show up on Mother's Day. And he will leave tomorrow to fly back to Nebraska. I asked one of the workers whether or not she thought that it was in the woman's interest that he does not have hospital privileges in Maryland, and that if a woman goes into stress, he cannot go to the hospital and act as her physician. And she said, oh, that's not true, because all he has to do is get permission. Now, I don't know whether that was supposed to be from the hospital or from the patient, so perhaps one of you could clarify that. Maryland has the worst laws anywhere, I believe. Thank you.
Well, if you look at, there's a difference between getting a patient's permission to be transferred versus the actual performance of the ability to be credentialed to perform procedures. And that's strictly related usually by legislation and also by hospital and also by training. So specifically, perhaps if you're a pediatrician, you would not be credentialed to do gynecologic procedures at a hospital. You would actually have to appeal to the board of that hospital, and you'd have to have the appropriate training and the appropriate ability to do that particular procedure under that particular hospital's guidelines. And so that's a specious statement, because you would have to actually petition that hospital board. The board would have to decide that you were able to perform those procedures related to any complications for the surgery you did. You have to be credentialed to do that and trained appropriately, and then be accepted onto the medical group there to do that.
I believe we have a question down here.
I'm Mary Bell from Virginia. I'm a citizen of Virginia. And we do have laws that were passed by the legislature, signed by the governor, the previous governor, and now we have a new governor who just says that he's going to not enforce them. And I wonder what we as citizens can do to help what the legislators have done.
Teach
Recall? Well, I would simply submit, I don't know if there's a recall possibility in Virginia or not, but I certainly think that you should encourage the state legislature, and we're happy to work with them, the leaders, to pass an enforcement module, which gives citizens the right to enforce that law. And this is exactly the case, a typical case, a classic case, where one elected representative takes it upon himself to make a decision that violates the will of the people as expressed by their duly elected representatives in the legislature. That is unacceptable. The people of Virginia should be outraged by that statement. What other laws will he choose to enforce or not to enforce? That is not his call. And the people should be outraged by it, to the point of calling for the enactment of at least an enforcement module like we have developed, and to give you the private right of action to enforce the laws if he won't.
It may be possible, depending on the state law regarding taxpayer standing and the nature of the regulations that he's declining to enforce, that a private cause of action could occur even now. In Minnesota, I'm involved in a case before the Minnesota Court of Appeals just rendered a ruling where the state of Minnesota provides taxpayer funding for our unregulated abortions, and the Department of Health reports the reasons that women are self-reporting for their abortion, and it doesn't compare adequately to the amount of abortions that we're funding. We sued on taxpayer standing, and so even without the AUL model, which would be extremely helpful, it would be like a qui tam action. Right. Even without the AUL model, there may be some recourse using taxpayer standing in your state. The other possibility is to, if you have a public official who is willing and courageous enough to do it, they may be willing to seek an order of mandamus from the courts if your courts are sympathetic. That's the other problem, is there seems to be a fair amount of collusion between the executive branch and the judicial branch in some states on this issue.
time for just one more question.
My name is Debbie Bradle, and I'm a nurse from California, and I work with the Abortion Pill Reversal Project. And Dr. Calhoun, I would like to ask you, are the statistics that you presented for the mental illness and preterm labor complications post-abortive as equally, do they match for medical abortion as well?
Part of the problem with the medical sides right now is there's not as much data, but we do know that medical abortions have a higher rate of necessary surgical completion. And we do know that from the data from China that in fact when you complete the abortion surgically, there's an even higher risk for preterm birth when you have to complete a medical abortion surgically to the tune of 200 to 300% increased risks. And if you have more than one medical abortion, it can be even higher than that. So there's some limited data out of China that talks about that, but the idea that there's the same amount of data for mental health and other things is not there yet. Would presumably be the same because the surgical procedure is not why the people have mental health issues. The preterm birth is the surgical procedure. The suicide is related to the abortion and the procedure, not related to the fact that you had a surgical or medical abortion. So the data is actually very compelling, particularly the mental health and preterm birth side as well.
Thank you all again for joining us today. Please join me in thanking our panel once again, and Charmaine as well.